SJC-11660, Commonwealth v. William P. Johnson and another.
Morning, still morning. You may proceed.
Thank you. Good morning, Your Honors. My name is Robert Sinsheimer.
I'm sorry, actually, we should wait until we get the clock.
I'm sorry, Your Honor.
That's not your fault.
I'm sorry, is it set for 5 minutes, Mr.? Okay.
Which frankly is what I was about to tell you. Technically, I represent William Johnson, but I'm going to speak for 5 minutes on behalf of both defendants, and Ms. De Palma will speak for 5 minutes on behalf of both defendants. Your Honors, I'm respectfully requesting that you reverse a conviction obtained in utter disregard of law from the moment of the issuance of the complaint right through the closing argument. There was disregard of the law to produce exculpatory phone records. There was disregard of the law to produce evidence of a deal with the government's allegedly star witness. There's an utter failure to follow Rule 36 and honor speedy trial obligations. There was a shifting of the burden in closing argument that was outrageous, triggering a request for a mistrial. And most significantly, there was an utter failure to follow the Constitution of the United States of America and the crystal clear precedent of this honorable court. Now, Your Honors had ruled in Commonwealth versus Welch that to be convicted of this statute, which we all know is a problematic statute, to be convicted, there was a requirement that the words uttered be fighting words. And we all know what fighting words are. They're fleshed out in cases, but we don't need to address it too much further because, to its credit, the government has finally acknowledged that these weren't fighting words in its brief, buried in a footnote, which I take as nothing more than artful advocacy. But it's there, and it's a concession, and it's a serious one. Later on, Your Honors ruled that there were errors, or at least one error in that Welch decision, and that was the fact that the statute could also be construed to prohibit true threats. Now, that doesn't apply to this case because it would have been ex post facto, as the government also concedes. But in any event, there's nothing here that suggests there's true threats. So you clearly have a prosecution that does not comply with the law as this very court construed it. What the government would like you to do is say, hey, look, this conduct is really bad, so reconstrue the law yet again. And I'm not here to defend the conduct, but I am here to defend the Constitution. You can't do that. If you could do that, they could just charge someone with any conduct in the world they think is antisocial and say it's a crime if later the SJC says it's a crime.
But one of the recognized exceptions to protected speech under the First Amendment is when the speech is an integral part to the criminal conduct, right?
Kind of, sort of recognized, if you will. There is the Gabini case, I might mispronounce it probably, but that has never been as crystally clear understood as the other crystal clear exceptions, such as true threats, such as...
Okay, but it's kind of, sort of. I'll go with you. Kind of, sort of.
It's out there.
It's out there. So why couldn't one characterize what happened here as speech integral to the criminal conduct?
Well, because then you're putting the cart before the horse. It's the speech that makes it criminal in this particular statute, in this particular case. Clearly, it's content-based. Clearly, the government intentionally elicited evidence from the alleged victims that the harm they felt to some extent was based on the speech, and that's fleshed out clearly in our brief. Now, notice, Your Honor, there's an interesting fact that's kind of buried in the record. The party that assisted the defendants, a gentleman named Colton, actually believed for a period of time that this was a practical joke. And that's how he was seduced into assisting. Now, I am not saying it's a practical joke. at all. I'm not trying to go that far. I'm not trying to defend the conduct. I've already said that. But I am trying to point out to you that the eye of the beholder is always significant when you're talking about the constitutionality of speech. And to
Is
suggest
this the
that,
guy that sent the email that said, if you're not miserable, I'm unhappy?
That's right.
that's what he said.
Yeah.
My client
he's-
didn't tell him to
This is
say
a
that.
practical joker?
He thought at the beginning it was.
Does a jury have to agree with that?
No. The
Or
jury.
the jury doesn't have to think that this was a practical joke, but it was intended to really make somebody's life miserable.
If Your Honor, please, we're not at this point talking about the jury instructions because we don't even have a clear statute. And so I'm going to repeat myself. I'm not defending the conduct here at all. Whatever adjective you apply to it, antisocial, sophomoric, there's very little that speaks well about the conduct. But you took the case, and I think everybody knows that the conduct itself is not the answer to the question. Not every tort is a crime. And this never was a crime. And you can't say so ex post facto, most respectfully. Unless there are further questions, I think my time's already up.
Time is up, so thank you.
So, thank you very much.
May it please the court, my name is Valerie DePalma, and I represent Gail Johnson. And I would just like to address a question that Justice Botsford just asked my co-counsel about why this case should not fall within the speech integral to criminal conduct exception to First Amendment protection. And I think the answer to that question is that we have to go back to this Section 43A itself and ask whether that statute gave notice to people that the exception is encompassed. Before the Johnson's trial, this court in Welch said that fighting words were one of the exceptions that the statute was intended to prohibit. And later, after they were convicted, in O'Brien, the court expanded the statute to also include true threats. However, reading the statute and considering the cases that have been decided under the speech integral or in violation of a valid criminal statute, it is hard to read that exception into the statute. There's a case that I cited out of Minnesota that had to do with a statute that prohibited assisting or encouraging suicide. And the government in that case argued that that it was a case where it was people communicating on suicide chat boards, and the defendant was encouraging people who are going on who are suicidal and coaching them initially as sort of a comfort, but then actually giving them advice about how to go about it. Anyway, the Minnesota Supreme Court said that this was not, it invalidated this statute, upheld it to the extent the assistance part, but said that suicide isn't a crime in Minnesota. So speech integral to suicide, while it's certainly harmful, isn't a criminal offense. And
Why isn't this a fraud? They misrepresented that they were the Lyonses and posted a contractual offer on Craigslist. And with the expectation that people would respond to the offer and show up or make calls asking to pick up the free golf carts or to put $300 down to get the motorcycle, a vintage Harley Davidson. Why isn't that a fraud?
Because the identity fraud statute in Massachusetts.
I'm not talking about identity fraud. I'm talking about classic common law fraud. It's a misrepresentation of agency, of fact.
But I believe you must have the intent to defraud in the sense of having an intent to deprive another of their property or their,
But
something of
that wasn't-
value.
Was fraud charged in this case?
It was, but it was dismissed because the judge found that while the other elements of the statute were there, the intent to defraud was not.
But it's fraudulent speech.
True, but in a sense, it's false. The
Yeah.
speech was false. And as the court phrased the amicus solicitation, it was to invite unwitting parties to contact the Lions to look for these products. But in terms of, I think, traditional fraud or identity fraud, those statutes have as their object to prevent theft, some kind of theft. And interestingly, in the amicus brief cited by, filed by Professor Volokh, he cites a new Court of Appeals case where they have a criminal impersonation statute which permits conviction, and they upheld conviction for just harm to reputation.
Why, what's the great difference, or what's the difference between this case and United States versus Sayre?
The difference is that Sayre was first, the statements in Sayre were clearly defamatory. I mean, they were portraying the victim as a person who was open to casual sex with strangers. And second,
But wasn't the basis of the holding that it was integral to the,
which was soliciting people to go to her home to potentially assault or rape her. I mean, there was the solicitation was to a crime, a cognizable crime, as opposed to here. And again, I'm not trying to mitigate that having people call you and show up at your door looking for things that you don't have isn't disturbing. But the question is that criminal under Section 43A?
Well,
Does Section 43A give notice of that?
just common sort of sense. This harassment's been going on. You contact the police find out that person X is posting false internet things, causing you all kinds of middle-of-the-night phone calls and people showing at your home and threatening to use your private information for various purposes. And so the police go and say, you gotta stop that. He says, hey, First Amendment, I'm doing nothing wrong here. Can't touch me, no crimes. I'm just harassing this guy, but I'm using just my speech. Is that right?
Well, I think that this court has recognized in many decisions that there's conduct that is terrible, but hasn't been criminalized.
Well,
yet.
could it be enjoined?
Enjoined. That's
Yeah,
Like a prior
would your
restraint.
response to a request for an injunction be that, hey, this is protected speech, I'm entitled to do this?
it certainly would be an argument to make that again, it has to be.
Would a court be prohibited from enjoining your clients from continuing with that conduct?
I think that it would be certainly a legitimate question. There's lots of.
What's the legitimate answer?
Well, Your Honor, I agree that, again, this was very disturbing conduct, but the question is there a criminal
But could it
statute?
be enjoined? Is it
I don't think-
entitled to
if-
First Amendment protection against an injunction?
If Section 43A doesn't give.
I'm not asking you
Oh,
that question.
okay.
Could you survive a request for an injunction on grounds that it was protected by the First Amendment?
I'm not sure, Your Honor.
Okay, thank you.
Thank you.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. In March and April of 2008, the defendants engaged in a multifaceted and varied campaign of harassment against the Lyons family, Jim, Bernadette, and their two adopted teenage boys. This included on the low end acts such as signing them up for magical, nudist, bisexual, and transsexual organizations. And on the high end, in a separately charged act, actually reporting to DCF that Mr. Lyons had abused physically his son, which caused a DCF worker to arrive at their house and inspect their son's body.
But that was not included in your harassment.
This is true, Your Honor. Four separate acts, apart from those, were charged as the violations of 43A. Those were.
It's not-
Why wasn't it included, just out of curiosity?
I think it was not included in error. It was not included based on a reading of the appeals court's decision in Breca, and that is that petitioning activity is activity that's protected by the
And
First
false
Amendment,
petitioning activity for the purposes of harassment.
which is precisely why I'm saying that was in error not to include that. It was perfectly permissible to include that as a possible component part of the 43A prosecution. but the
So if it's not fighting, none of these things is fighting words and none of them is true threats?
We have conceded that the application of the true threats exception wouldn't apply in this case due to due
Nor the
process
nor
concerns.
the fighting words, right?
Nor the fighting words.
So,
What we would rely on primarily is the exception, the long-standing exception that's been recognized in Stevens, in the Supreme Court case Stevens in 2010, and more recently in Alvarez in 2012, the speech integral to criminal conduct.
what is that? That's what you're basically doing.
We think that is the most correct, most faithful to the First Amendment jurisprudence reason for upholding this prosecution.
Let me just ask you, if it were an identical set of facts which took place subsequent to the decision of this court, which includes true threats, would you be maintaining that this was a true threat?
The last two of the acts in those four, yes, Your Honor. The email in which he taunted the Lions and provided their personal identifying information and said, if you're not miserable, I ain't happy. And also the last one, sending the letter from Brian falsely accusing Mr. Lyons of sexually molesting a young former employee of his and then threatening prosecution. We would submit that those would qualify under the true threats exceptions to First Amendment protection.
But they, for reasons having nothing to do conceptually other than the timing, you can't do that here.
We can't do that here, but we would rely on, and I think it's perfectly permissible to rely on, the entire course of conduct as being within that exception first announced by the Supreme Court in 1949 in Gaboni, where they said it has never been deemed an abridgment of free speech to make a course of conduct illegal merely because that conduct was in part initiated, evidenced, or carried out by means of language, spoken, written, or printed. This is the paradigm example of this.
What do you, but the argument made in response is, that's all very well and good, but there isn't notice in the way the statute is constructed that that would be the case.
Well, I would submit there is absolutely notice here. And the reason is, going back to this court's opinion in Welch, it looked at several states' harassment statutes and looked at whether they provided adequate notice with regard to their application to speech specifically. And it looked at features in those statutes which are common to features in 43A, including a mens rea of maliciousness, including specified harm to an identifiable individual, including targeted acts toward that individual, including a reasonableness requirement that not only serious alarm, but it must be reasonable to a normal person that this would cause serious alarm to, or in the words of the statute, substantial emotional distress. Those subjective and objective components, the targeted harm, the malicious mens rea, are all saving features that provide more than adequate notice that this type of behavior is illegal.
This type of speech is illegal.
This type of speech is illegal, yes.
Yeah, I'm confused by your due process argument. True threats has never been viewed a protected form of speech.
Correct.
But yet you say that because we didn't articulate that until after this case was done, that it would be unfair to say that they are guilty because what they did was true threats.
Well, yes, Your Honor, the concession was made in view of this court's footnote 14 in Welch, where it expressly says the true threats exception to protected speech does not apply in the 43A context. I completely agree. I think that, and when the court dialed that back in Borowitz, if I'm getting that name right, I think it was correct. So it would be perfectly permissible, I think, because true threats is a longstanding exception to First Amendment protection, to uphold those last two acts that I mentioned as unprotected under that rubric.
So you say there's a due process concern because we had explicitly said that true threats are not included, but Welch made no reference to the speech integral to criminal conduct, and therefore there's no due process concern?
Actually, Welch did. Welch cited Gaboni and cited the language that I just quoted from that case. And it also, and this is an important point, my sister mentioned that Welch had limited 43A to fighting words, and that exception to First Amendment protection, it in fact did not, and I quote, "Any attempt to punish an individual for speech not encompassed within the fighting words doctrine or within any other constitutionally unprotected category of speech." This court was very explicit when they said that it's not just fighting words, not just true threats, but any kind of unprotected speech. And in fact, this court cited Gaboni. Now, there are examples throughout history, beginning with the Supreme Court's earliest cases of speech that is inseparable from the conduct it engenders. The most famous example would be the famous one of shouting fire in a crowded theater. That's an example in Justice Douglas' words of an instance where speech is brigaded with action. No different here. When no one would dispute, I think, that the defendants couldn't themselves have gone to the Lion's door 30 or 40 times in a single night, asked after a golf cart that was supposedly for sale, and when they were rebuffed, act angry and miffed and suspicious and direct their anger at the Lions. They couldn't also the next night make their phone ring off the hook. What they did was they used the internet to induce unwitting parties to do the same thing for them. This was using the internet to shoot these responders and callers at the Lions' home as if from a cannon. And their home, of course, is the place where they're most entitled to peace and repose, and it disturbed their most basic sense of that. Now,
Is it your view that the term seriously alarmed can be alarmed about any harm, or is it limited to physical harm?
well, no, it is absolutely not limited to physical harm, and the facts here show conduct on the part of the defendants that would engender serious alarm, not only in fact did in the Lions, but in anyone, because they're threatening release of their personal information which they had, and they're also threatening a wrongful accusation of one of the gravest crimes, which is sexually violating a young boy. These sorts of things would cause serious alarm in anyone, as would the two.
And I take it that your theory is not that each of these events in and of itself in isolation has to create serious alarm, but the pattern has to create serious alarm.
That is our theory, but should the court rule that each individual instance had to amount to serious alarm and had to amount to would cause substantial emotional distress in a reasonable person, if that was the court's ruling, we have that with respect to at least 3. We would admit, as my sister points out, that the email, there was no specific testimony as the email. Ironically, that's one of the most threatening and egregious acts here, but there was no specific testimony about their serious alarm as to that act. But as to the other acts, there was testimony that would clearly meet the standard of serious alarm, and so it would suffice under any standard. But I would submit that the statute the statute wording ties the requirement of serious alarm to the pattern, not to the individual instance. I see my time is up if there are no further questions.
Thank you.
Thank you.